Good morning, Ms. Gunn.
SJC-10748, Finch versus the Commonwealth Health Insurance and National.
Good morning, Ms. Palmette.
Good morning, Your Honor. May it please the Court. I represent a class of 43,000 legal, tax-paying residents of our Commonwealth who lack access to employer-subsidized health insurance and have been denied the opportunity to participate in Commonwealth care, an integral part of the state's 2006 health insurance reform law, solely because of their alienage. As a result of this exclusion, many of these legal residents lack health insurance. Many face unmet medical needs and unaffordable medical debt. The four questions reported by the single justice here require this court to decide whether Section 31A of Chapter 65 of the Acts of 2009, the law which excluded the plaintiff class from Commonwealth care, warrants strict scrutiny under the Massachusetts Constitution. The answer to that question is yes, for two key reasons. First, the equal protection guarantees of our Constitution provide protections against discrimination that are at least coextensive with those afforded under the federal Constitution. And that protection extends to legal aliens, providing that they are a suspect class. And second, under the reasoning and analysis offered by this court in Doe versus Commissioner of Transitional Assistance, the discrimination affected by Section 31A, denying legal aliens access to state-funded benefits without direction or compulsion of any uniform federal immigration law, is the very paradigm of a case demanding strict scrutiny. Doe is without question the pivotal case here. But
is it your position that alienage is the same as national origin?
It's our position, Your Honor, that alienage, that discrimination against alienage is one of the forms of discrimination against national origin that is encompassed by Article 106.
106 talks about discrimination based on sex, race, color, creed, or national origin.
Yes, Your Honor, and we believe that discrimination on the basis of alienage is included within Article 106's protections against discrimination on the basis of national origin, and is also more broadly included in the guarantees of equal protection provided by the Constitution, which this Court has repeatedly asserted are coextensive with those under the federal Constitution.
But in 106, they could have said alienage, couldn't they, if they wanted to?
Your Honor, I don't think that there was any reason to believe that the ratifiers, as we show in our reply brief, the point of Article 106, the amendment to the Constitution that it provided, was an equal rights amendment. It was designed to expand the rights provided under our Constitution. And both before the ratification of 106 and after the ratification of 106, this Court has always held that alienage, it has always stated that alienage is a suspect class. The Court repeated that recently in the Doe case, which is the critical case here. This Court has never read Article 106 as retracting the rights of vulnerable groups under the Massachusetts Constitution, and there's absolutely no reason to believe that it was the intent of the framers of 106, an amendment designed to heighten the rights and provide the people of Massachusetts rights greater than those under the federal Constitution. There is not a scintilla of evidence to believe that it was designed to provide this Constitution's historic commitment to equality as less robust and less protective than those under the federal Constitution.
Well, let me step back. You're here in state court as opposed to federal court, I assume, because you're not contending that under the Equal Protection Clause in the United States Constitution, what occurred is unconstitutional.
Our claims are solely under the state constitution, Your Honor.
Now, does that mean then that, and let's assume that we will provide equal protection to aliens, that means that whatever we must provide must go beyond that of the federal Constitution for you to prevail. correct?
I think, Your Honor, you merely need to find that the rights here are coextensive, but coming from the state constitution.
It seems you can choose to be in state court and still ask us to adjudicate a federal constitutional claim. So I take it that you are unequivocal that you have waived it under the federal constitution, right?
Your Honor, this case was originally brought with federal and state claims. The Commonwealth removed the case to federal court.
They're entitled to do
And
that.
because we believe very strongly that this is the appropriate tribunal, we then waived our federal claims.
Okay, so those are waived, but we could, in theory, hold that the rights are greater than, coextensive than, or less than. Now, I'm not sure what happens in the last category, right? But if we conclude that they are less than, in this case, you would lose.
Yes, Your Honor. I mean, well, Your Honor, we would have a very difficult road. We would then have to
And so you're saying if they are coextensive with or greater than, you win.
if they are greater than or coextensive with those under the federal constitution, we believe strict scrutiny would be required and we would win. If they were less than, then I think we would be dealing with rational basis review. For the reasons we cited in our brief, we think we could still prevail, but it would be a much more difficult case for us, without doubt.
Now, you know that there is an ongoing discussion in this court and in this Commonwealth jurisprudence under our Constitution is that we don't have strict bands. We don't have strict scrutiny, intermediate scrutiny, rational basis scrutiny. We have, and there's some jurisprudence in the United States Supreme Court that is the same, which is that there's not a huge river that divides the three bands.
Yes, Your Honor. But we believe that this case is clearly, whichever formulation you use, is one in which the most searching judicial scrutiny is required, both because this discrimination, I mean, we have here a statute, Section 31A, which discriminates plainly against legal aliens. The discrimination is clear. A very vulnerable group, a politically powerless group, and we have here discrimination that, in contrast to the situation before this court in Doe in its discussion of Section 210A, it was neither compelled by nor directed by any uniform federal immigration law. So here what we have is the state facing undeniably budget woes and deciding to exercise its discretion to put to, in a sense, deal with some of those woes on the backs of a politically powerless group. That is precisely the kind of situation which warrants demanding scrutiny, whether or not the court is using a very strict tiered approach, whether the court is using a more nuanced approach, because we have a vulnerable class, we have an important and absolutely essential public benefit,
But we didn't. Massachusetts didn't make up this category. It's one that is embodied in federal law as a national policy that immigrants are supposed to be self-reliant and are not, and that's one of the reasons why there are a lot of federal benefits, both state and federal shared benefits, that are not available to them. So we didn't pick out this group. It was picked out for us, wasn't it?
Well, Your Honor, certainly the state in 31A referenced and used language that comes from the Federal Welfare Reform Act. But the Federal Welfare Reform Act recognizes and leaves to the state vast discretion with respect to state-funded benefits and with respect to a program like Commonwealth Care. And I think it's very important here to understand that this situation is quite different factually than that before the court in Doe. And that's why the Doe court's reasoning here leads us to a different outcome. In Doe, in Section 210A, the court was discussing the state's version of TANF, a federal state program created under federal law and which under federal and state law had to comply to federal eligibility requirements. And the court noted in Doe that if the state had not, in fact, enacted 210A, the exclusion of aliens from the TANF program was going to happen anyway by virtue of federal law. That's not this case here. This case, our plaintiff class were covered under Commonwealth care since 2006. And twice since 2006, the Federal Department of Health and Human Services indeed approved a federal demonstration project. There was no problem under federal law with the plaintiffs receiving Commonwealth care.
But isn't there a practical consequence, which is that during the 3 years that they provided care for aliens, they were paying $1 on the dollar, while for citizens, they're only paying 40 cents on the dollar?
Well, there's no doubt that it was more expensive per capita if we divide the class this way for the state, Your Honor, for the state to cover the plaintiffs. But first of all, the plaintiff class are not the only people in this state receiving Commonwealth care for whom the Commonwealth does not receive federal reimbursement. The stipulation, it's clear, there are other members of Commonwealth care for whom the federal government does not provide any reimbursement. They are absolutely similarly situated to the plaintiff's class in every single way except they are citizens, they are able to vote. The legislature here did not simply make a decision based on expenditures. This legislature made a decision that to exclude only a politically powerless class, and that is precisely why judicial scrutiny, searching judicial scrutiny, is required here.
So
Mr.
is it?
Foreman?
I'm sorry.
I'm curious about the case of Espinoza versus Farah. Are you acquainted with that?
Yes, Your Honor.
Well, there's some language there I want to read to you in that case. Now, that's a 1973 U.S. Supreme Court case. They said, a law that discriminates on the basis of national origin does not, quote, make it illegal to discriminate on the basis of citizenship or alienage.
Yes, Your Honor. That case was decided, the Supreme Court decided that case under Title VII. It was a case in which the Supreme Court was construing federal employment, statutory employment protections. And critical to the Supreme Court's analysis in that case was the fact that federal law itself allows different employment status for different statuses of aliens. And the court felt that there would be an inconsistency in federal statutory law if it construed alienage as within the category of national origin for Title VII purposes. This court, since Espinoza was decided, I mean, first of all, Your Honor, there's no reason to believe that Espinoza applied to the constitutional question, and the court there was clear. And since Espinoza was decided, and since Article 106 has been ratified, both in the King case and in Doe itself, this court has treated alienage as a suspect classification.
Would you just remind me when 106 was ratified?
I believe 1976, Your Honor.
So if I understand your argument, if the legislature had said, we're going to limit Commonwealth care to what? Those persons for whom the subsidies would receive federal reimbursement, that would be okay, even though 99 or 98% of them might be aliens because the federal reimbursement doesn't apply to those aliens? That would be okay?
Well, I think, Your Honor, we might have contend in that case that there was disparate impact discrimination, but it would have been a much harder case for us to bring because we would have had to show that there was discrimination, because the discrimination, as you suggest there, would purely be a matter of disparate impact. Here we have facial disparate treatment discrimination. And so the only question before the court, in a sense, is whether, given the clear discrimination here, should strict scrutiny apply. If it was disparate impact, we would have to have gone further. We could not have brought the facial case, and we would have had to show that the discrimination was, in fact, on the basis of alienage. We don't have that case before us, Your Honor.
And I take it in that case it would be essentially because the federal government didn't reimburse certain people.
The question before the court then would have been whether or not that was pretextual. What was the nature of the program? There might have had to have been a record brought. It's not this case. In this case, the discrimination is on its face. It's undeniable, and it's clear that the state was exercising its own discretion. The federal government had no problem with the state paying out. This federal government provided no uniform rule, and that's what the Doe Court said was required to justify rational basis review. That is what every single court that has looked at this, the New York Court of Appeals, the Maryland Supreme Court, the Arizona Court of Appeals, every court that has looked at a pure exercise of state discretion, cutting state funding on benefit programs to legal aliens, has said strict scrutiny is applied.
So before you go, one other question. If the state had said, we will spend 40 cents on the dollar for everyone, for citizens, that mean you get the full Commonwealth care. For others, you go to Commonwealth Bridge and you get basically 40 cents worth of medical care. Would that be permissible because they're basically paying 40 cents for everyone?
If the program was structured in such a way that there was no discrimination, Your Honor, I think that would be a very different case. We are not questioning the fact that the federal government has the rational basis review applies when the federal government discriminates on the basis of alienage. The problem here is that it's the state doing it on its own.
Ms. Palmer, let me ask you this. If you look at it through the other end of the telescope, namely citizenship as a requirement, right? Because that's really what we have here.
Yes.
Where do we fall on the continuum of from rational basis to strict scrutiny? In other words, there are lots of cases that have upheld citizenship as a requirement.
Well, Your Honor, there are lots of cases. We don't question those cases. Those cases deal with a well-recognized exception, in a sense, for political functions. We are a political community, and citizenship may be a requirement for participation in a political community, for voting, for office holding, for teaching.
What's political about teaching?
Well, the Supreme Court
I know what they've said.
That it is political. So they talked about that teachers have a great deal of, extending political values to the next generation.
And though we don't teach citizenship anymore in the public, that's a separate issue.
Well,
so you're saying once I get outside the broadly interpreted political sphere.
Once we get outside that, when we're talking about socioeconomic benefits, then legal residents, members of our community, tax-paying members, members of our community to whom the state mandate, the health insurance mandate applies, should not be discriminated against. It's precisely because they are politically powerless, in fact, precisely because, unlike citizens, they can't go to the ballot box tomorrow and vote against the legislatures who voted for this law. This is precisely the reason why strict judicial scrutiny should be applied. Thank you,
Ms. Palmer.
Thank you, Your Honor.
Good morning, Mr. Salinger.
Good morning. As plaintiffs have conceded and as this court unanimously held just 8 years ago, state laws that adopt or conform to federal immigration policies are subject to rational basis review, even if in so doing they discriminate on the basis of alienage. That was the first holding in Doe, which, contrary to plaintiff's suggestion in their reply brief, was not mere commentary, not mere extensive commentary. It was a holding of this court. The attempt by plaintiffs today and in their reply brief to distinguish that Doe case is in error. Plaintiffs say that the federal law at issue there barred Massachusetts from opting to continue to fund those benefits, the TAFDC benefits, using only state funds. That's not correct. As this court correctly discussed in footnote 4 of Doe, it was a choice of the Massachusetts legislature as a matter of state law to define those benefits as being limited to those that are federally funded. But that was not a requirement of the TAFDC program or the federal TANF program. Indeed, if we look at the relevant federal statute, 42 U.S.C. section 608, we see that the federal financing scheme had by then been changed to a block grant form, And what Congress said is, although there are certain kinds of folks who aren't eligible and certain kinds of services that aren't eligible, you just can't use the block grant monies for that. There was no federal requirement saying you can't provide the service. And of course, there was no requirement in the 1996 Welfare Reform Act that was being considered in the Doe case that barred Massachusetts from funding that. The legislature had a choice in the Doe case. Do we continue to fund the benefits in full or do we not? And so the attempt to distinguish Doe factually is factually incorrect.
But isn't there a difference between the welfare program in Doe and this program in that in Doe, the legislature had no choice because the money was intertwined to remove the aliens for it, because the money was so interwoven that it would prohibit the program that they had in place to use federal funds for aliens.
Whether it was interwoven or not was really a policy choice by the Massachusetts legislature. Federal law would have permitted the Commonwealth to do there, as it does today in the Medicaid program, to have a single program where some of the benefits get federal reimbursement and other benefits don't. Today in Medicaid, under the
Right,
waiver
I understand
process.
that, but the program that was in place when the Welfare Act was passed by Congress could not accept federal funds and still have aliens as part of that program.
No, putting aside the state law question, as a matter of federal law, the legislature could have opted, beginning in 1997, to continue a single program that funded both citizens and aliens no longer eligible for federal reimbursement, and then paid for the second part of costs using entirely state monies. There was no federal law prohibition on that. What there was a prior legislative choice to define the program as federally funded benefits. But that was a decision by state law, and so it wasn't mandated by Congress. That structure of the program, there are very good practical reasons for that program at that time, why a choice was made to start a new separate program rather than include things under a single umbrella. It's my understanding that unlike today in Medicaid, it was much more difficult than with that program to separate out the funding and make sure you got the proper federal reimbursement. But that was not a mandate of Congress, and the assertion that it was is wrong factually and legally. So this case really is indistinguishable from that first holding in Doe. Just like the legislature made the choice in 1997, Section 210A of that act, under consideration in Doe, to adopt the same federal 5-year eligibility rule that Congress had established as a matter of national immigration policy. And this court held that that was subject to rational basis review because it made no sense to say that Congress's adoption of those rules under the federal Constitution is subject to rational basis review, but when Massachusetts follows them, all of a sudden strict scrutiny is required. The same is true here. We're dealing with the same Welfare Reform Act requirements.
Mr. Salinger, would you agree with me that under Massachusetts law, at any event, we don't have these, bans so that if it's strict scrutiny, we say down it goes, or if it's rational basis, up it stays, right? We've done some switching at the interplay between the different bands.
And certainly, even if strict scrutiny applies, that doesn't necessarily mean down it goes.
No, and if rational basis applies, it doesn't necessarily mean up it stays.
Absolutely,
Okay.
as this court has made clear
So let's
recently.
just take a look at some of the reasons here. Let's assume that you're correct on the standard of review. It seems to me that if one is looking at people who have moved to the United States and a federal agency has decided move to the Commonwealth, and a federal agency has decided that they can live here and they are receiving welfare benefits, in other words, whatever reason the Commonwealth might have of wanting to have people here, it certainly isn't to have them be here and contribute essentially nothing in terms of, and I don't want to suggest all welfare recipients contribute nothing, but in terms of tax dollars or health insurance or any of the other workers' comp insurance, the myriad requirements that we impose on people who are legally here, I can see that there may be a policy choice that says we want to discourage people like that from remaining in Massachusetts because they are a net drain. Here, it seems to me that you have at least a going-in assumption that these are tax-paying people who are required to carry health insurance, who have to do all of the other things that they contribute to the fiscal well-being of this Commonwealth. and yet we somehow withhold from them access to some of the things that government provides.
If I may paraphrase the Tenth Circuit's decision in the Soskin
Not
case.
very helpful with me, but that's fine.
Well, the Tenth Circuit looked to this court's decision in Doe for guidance, and consistent with Doe,
I'm delighted.
said that this rule that we're talking about may or may not be a bad policy, but it's Congress's policy. It's Congress that has decided that the national immigration policy bars federal funding for aliens in this category, and Congress went on in 42 U.S.C. Section 1601, Paragraph 7, to say that where a state chooses to adopt that identical federal classification, that furthers the national immigration policy of fostering independence in aliens. That's why, just as in Doe versus Commissioner, this case is very different from the Graham case, the prior 1971 decision by the U.S. Supreme Court, where Congress hadn't set any national immigration policy with respect to eligibility of aliens for benefits.
It's an interesting argument, and I take back my comments about the 10th Circuit, but let's say we have a governor who is trying desperately to attract high-tech, other kinds of things to the Commonwealth, and the United States, looking at 300 million people and 50 states and 6 territories, says as a general matter, we want to limit what we, the federal government, pay because we think that that's a beacon that is attracting people, not just some of the other things that have attracted people. And so we're going to say from a federal policy point of view, and the Commonwealth says, yes, but that doesn't really work for the Commonwealth. You're saying that's purely the legislature's decision.
Well, if I understand your hypothetical, you're asking, what if the legislature, instead of adopting the federal rule, did some different version of it? And
I am asking that, but I'm also asking you about rational basis. That if I'm looking at what is rational in Massachusetts, assuming that we're at rational basis, does it make any sense for the Commonwealth, on the one hand, to be saying, we want all these people coming into Massachusetts because we have had a net loss of people living in Massachusetts, and yet we are now going to have a policy that says that we will not provide all of the resources that other legal residents, tax-paying residents, have access to in the Commonwealth.
Chief Justice Marshall, you may be asking, would rational basis be satisfied here?
That's what I'm asking.
And so first, it's my understanding that the single justice reported some specific questions, but not the case as a whole. And so if the court were to hold, as we suggest it should, consistent with Doe, that rational basis is the standard, then it would go back for the single justice in the first instance to decide that question. I expect if the Commonwealth is involved there rather than just the Connector Authority, we would argue there is a rational basis. And indeed, this court, quite eloquently, as it always is, in the second part of the Doe holding, explained there why the state's own 6-month residency requirement met the rational basis test, in part because it not only was consistent with, but it furthered the federal national immigration policy. Certainly here, where the legislature has opted, as it did in the first part of Doe, to adopt the very rules, the very classification established by Congress, there would be a powerful argument that there is a rational basis for that as well. Chief Justice Marshall, you had asked plaintiff's counsel what happens if the requirements of equal protection are the same for these purposes under the Massachusetts Constitution as under the federal Constitution. And I think the answer clearly would be, therefore, rational basis review would apply.
No, what I was saying is that the way we look at we don't have to decide whether, we can reach the question under the Massachusetts Constitution regardless of whether it is the same, greater than, or less than. I wasn't asking, what if we say it is the same as?
Case it's helpful to the court. Let me just remind the court of 2 Supreme Court decisions that it discussed in Doe that help explain why the holding in Doe is so very consistent with the rule under the United States Constitution. Commonwealth is not arguing for some weakened equal protection standard here. First of all, as I'm sure you know, in Matthews versus Diaz, the U.S. Supreme Court held that when Congress, there involving Medicare, establishes 5-year residency rules for aliens, that federal rule is subject to rational basis review. But also, this was cited in footnote 12, the Yakima Indian Nation case, was not an alienage case, but very similarly, it involved Congress's plenary authority there to regulate relations with Native Americans and Native American tribes, very similar to Congress's unusual plenary authority with respect to aliens. In that case, Congress had authorized, but not mandated, not required, states to exercise civil or criminal jurisdiction in Indian Territory, as it's still known. The state of Washington exercised some but not all of that authority. The U.S. Supreme Court held that with respect to an equal protection challenge, it was subject to rational basis review because Congress had set the policy and the state of Washington chose to follow it. That's exactly what this court held in Doe with respect to Section 210A, and this case is indistinguishable on that point.
Now, what about the argument that Ms. Parmet makes, which is that it's only aliens who are barred from federal funding that have been prohibited from Commonwealth care, that there are other citizens who also don't receive federal reimbursement which have not been excluded?
Right. Alienage is different. Congress has plenary authority to set special rules there that it doesn't have with respect to other classes of people. And here, Congress, although it has not mandated that states follow the federal rule for aliens, has clearly allowed Massachusetts to choose to do so, and it has done so. Now, I think perhaps part of what plaintiffs are arguing in making that point is that we're talking about state money here, a choice whether to spend state money or not spend state money. But we want to remind the court that that was true in the Doe case, just as it was true in Soskin and Sudamir and Sid, because Congress in the Welfare Reform Act is barring the expenditure of federal funds on this class of folks, but merely allowing states to adopt that same federal rule. States always have the choice to use state funds, but the fact that the state has followed the federal rule with respect to aliens, in this case for Commonwealth care, and yet opted to provide other small dollars, according to the stipulation, but other coverage that's not subject to federal reimbursement, does not somehow trigger some stricter scrutiny. The point is that there's nothing inherently suspect about Congress making rules for aliens. It gets to do that, and as this court held in Doe, it therefore, as a matter of both Massachusetts constitutional law and federal constitutional law, is not inherently suspect when the legislature adopts and follows the very classification that Congress has settled upon in its unusual authority to regulate benefit eligibility for aliens.
Mr. Salinger, I don't know if this question will make much sense, but let me try it. I understand your argument about Congress has plenary authority in alien cases and in Native American cases. For myself, I don't find that very helpful because for a variety of reasons. But taking just the alien cases, and there's a huge body of law, I'm just wondering, and it's triggered by your reminding me, thank you, that Matthews against Diaz had that 5-year wait period. Are there cases where, other than my attempt to parse out what happens when somebody is legally here but not a fully financially contributing member, as this group of people appear to be, they are tax-paying legal residents, where a court has said you can have this ban for the rest of this person's working life, and it's okay, as opposed to a temporal thing, because there's a whole body of constitutional law that lets states and the federal government set temporary, you have to be in a state for a certain period of time before you can, and then there's a variety of things. So I'm looking for whether that's a distinguishing feature here or not. Distinguishing from Matthew against Diaz, for example, which was for a limited period of time.
As is this. This is a 5-year rule, as in Matthews. In one direction, where states without any following of a rule set by Congress have adopted their own rules. This is Graham. The U.S. Supreme Court has said, no, states can't just decide we're going to set up, in that case, one of the states had a 15-year residency requirement, and the court struck that down. But we've also cited cases that are not benefits cases, but in other contexts.
That's what I was thinking,
having to do with driver's licenses, having to do with admissions to the bar. Instead of having a temporal residency requirement, states have been upheld as a matter of federal constitutional law when states limit illegal aliens' ability to get certain rights or benefits, or where states have...
Well, illegals is a whole other category.
Right, and some of plaintiffs' class are here illegally as well. They may be remaining here under color of law. Federal government knows who they are. They're not deporting them. But yeah, it's a hodgepodge. The other cases we cite, Leclerc and Bredesen, in our brief, are examples of cases where distinction was made between non-immigrant aliens, folks who are here temporarily, they're not allowed to or not expected to establish their domicile or legal residence in this case. Leclerc was a Fifth Circuit case saying it's constitutional not to allow non-resident aliens to be admitted to the state bar, even though other aliens were allowed to be admitted. So that's an example of a state following a different kind of classification that has been established by Congress, with a holding that when the state did so for equal protection purposes, that classification was subject only to rational basis review.
Okay, one more question, at least for me. You're not suggesting that it would be appropriate for the state to say that legal and illegal aliens are, as you say, a hodgepodge, and therefore we can bar all aliens from certain privileges in this Commonwealth, are you?
No, I'm not, Your Honor. The Commonwealth is not making that argument. Contrary to plaintiff suggestions, the Commonwealth is not asking the court to somehow restrict prior holdings or restrict equal protection. We acknowledge that the equal protection provisions of the Massachusetts Constitution, unlike many other provisions of the Constitution, apply to both citizens and to non-citizens. The point of this case is aside from the question of national origin, which I haven't spoken to, but we address in our brief, this case is on all fours with Doe. The court has already decided this case we submit, because there is no distinction that can be made factually or legally between the legislature's adoption of the Welfare Reform Act rules in this case versus the identical action by the legislature in 1997 in Doe.
Thank you, Mr. Salinger.
Thank you, Your Honor.
Mr. Valvo, he didn't use up your 2 minutes.
Let me see what I can do in 2 minutes, Your Honor. Carl Valvo for the Connector Authority. Following up immediately on Justice Gantz's question, it's important that we're not arguing that legal and illegal aliens are
Similarly
situated. In fact, we insist that the court be aware that the group of aliens who have been disentitled from Commonwealth care include both. Commonwealth care applied to qualified aliens and to so-called PRU-calls. The PRU-calls are here under, they may have been admitted illegal, they have entered the country illegally, but they're here as a matter of federal forbearance. That's not, to me, the same as being a legal immigrant, but they have some color of law in that the federal government...
Is that what in the old days we might have referred to as out of status?
I'm sorry, Your Honor?
Out of status?
Albert?
Out of...
Oh, out of status. I don't know that term of art, but what it means, PRU-call means that they have some evidence that the federal government knows they're here, but is taking no affirmative action, at least at the present time, to deport them.
On an individual basis or by category?
On an individual basis, although there may be regulations that govern that discretion. That's a prosecutorial discretion type thing.
So your point is that, I take it, and forgive me for repeating it, which is that the legislature has set certain categories of people, and they may resemble each other in the sense that in this case they're aliens, but it hasn't just lumped them all together.
Well, this goes to a point about whether or not the federal government is indifferent to the inclusion of aliens in a state program, because among the PRU-calls, federal law requires a state to make an affirmative statement that it is making a state public benefit available to those individuals. And that is why the language in the definition of resident in Commonwealth Care Statute specifically includes the PRU-calls. That is not a matter of federal indifference. The federal government is saying, look, if you're going to extend benefits to this class of aliens, we want you to say expressly what you're doing and that everyone knows it. With respect to your question concerning bands of equal protection, Chief Justice Marshall, I agree that there is a conversation about that. but one would not know it from reading Doe. Doe approaches this problem in a traditional equal protection framework. Is it rational basis or is it strict scrutiny? Those terms are...
No, it's not that they don't determine outcome, but it makes a it makes a great difference as to how you then, I'm not suggesting we've upended strict scrutiny and rational basis, but just what one then looks at. And I think Mr. Salinger reminded me that even if we get into the discussion that I was having with him, that may not be here.
That's right.
Okay.
That's right. I just wanted to comment on that.
So Mr. Valva, let's assume that the state established a job training program. We're going to spend some state funds to improve the workforce, and said, but we're going to adopt the same limitation. Congress has enacted this limitation in the Welfare Reform Act of 1996. We're going to restrict who can get trained in this program and we're going to eliminate or limit the participation by qualified aliens who haven't lived here for 5 years. Same analysis?
We're talking about a state public benefit?
Yeah.
I would have to look at the definition of state public benefit again to see if that were considered to be a benefit for an individual as opposed to a state initiative for larger purposes, although I imagine it could be both. And I would also want to know if the federal government of Congress has addressed the issue of workforce training for aliens. And there may be distinctions there. So we just can't take Congress's limitation in this one area and automatically extend it to any program the state may sponsor? That's right. But to answer your question, let's assume that it is a state public benefit, and if the state adopted the uniform federal eligibility criteria in the sections that are at issue here of PERWARA, then I think the answer would be yes, because if Congress has determined that these are the kinds of public benefits and invites states to employ the federal criteria, if a state were to do so, it would be doing so at the behest of and in accordance with the federal government.
Well, I'm sure the state's doing it because it only has limited funds, and so wants to spend them in certain ways, and not doing it as the request of the federal government. It's one of the features of this case that this Section 31A is almost certainly prompted by fiscal considerations, and not the state having its own immigration policy that happens to be consistent with the Congress's. What we have here is a way of reducing spending in a program at a time when all of state government had to reduce spending. Justice Gantz pointed out that if the connectors, and the legislature's commitment is to make as much health insurance available to as many people as possible, one can extend health insurance to 2 eligible individuals as opposed to 1 alien. And I don't see that as an animus against aliens in particular, but it does further a state policy of maximizing health insurance. And one should realize as well that there are many aliens who continue to be eligible for Commonwealth care, not because the state has decided that they're more worthy, but because the Congress has. You mean those who've lived here more than 5 years? And other subcategories? If they're qualified aliens and they're 5 years or more, or any number of subcategories that are deemed by Congress to be worthy because of humanitarian or other foreign policy reasons.
Thank you, Mr. Valvo.